All right. Well, thank you all very much for joining us. My name is David Egner. I'm with the Office of Special Education Programs in the U.S. Department of Education, and I'm pleased to introduce our speakers for today, who will be presenting on the Department of Justice's technical assistance on testing accommodations for standardized exams. And with us today is Roberta Kirkendall. She is the Special Legal Counsel for the Civil Rights Division in the United States Department of Justice, and Nabina Sinha, who is a trial attorney for the Civil Rights Division, also with the U.S. Department of Justice. With that, I'd like to turn it over to Robbie. Robbie?
Thank you, David. Welcome, everyone. So today we're going to be talking about testing accommodations for standardized exams. And the types of standardized exams that we're focusing on are the SAT and ACT and other sort of college readiness exams that states are now using. So let me go over, can you advance the slide, please, David? So the topics that we're going to address on this call include basics on testing accommodations, documentation requirements, the weight of our technical assistance, what to do if you're having trouble getting appropriate testing accommodations for your students with disabilities, and recent litigation and a best practices report that has been produced as a part of some litigation on these issues. David, can you please advance the slide? Thank you. So, you may be wondering, what are we talking about? There is a provision of the Americans with Disabilities Act that's on your screen right now. It's located at 42 U.S.C. 12189, and it's a specific provision of the ADA that states the following, and I'm going to read this in case anyone that's listening or watching has a visual impairment. Any person that offers examinations or courses related to applications, licensing, certification, or credentialing for secondary or post-secondary education, professional or trade purposes shall offer such examinations or courses in a place and manner accessible to persons with disabilities or offer alternative accessible arrangements for such individuals. So that's the operative statutory language of the Americans with Disabilities Act, and that is where all of our, where the roles and responsibilities stem from under the ADA and what we have been enforcing for the past 20-some years, 25 years. When the department, David, could you please advance the slide? When the department, when the ADA went into effect, the department implemented regulations for the Americans with Disabilities Act, and the department put in extensive regulations with respect to this statutory provision that we just talked about. And one of the key parts of this regulation is on this screen here. And what it states is that testing entities must assure that the examination is selected and administered so as to best ensure that when the examination is administered to an individual with a disability that impairs sensory, manual, or speaking skills, the examination results accurately reflect the individual's aptitude or achievement level or whatever other factor the examination purports to measure, rather than reflecting the individual's impaired skills. So that's sort of the heart of the matter. That is why a person needs testing accommodations, because what we're trying to do through this provision of the ADA, which is based off of earlier provisions of Section 504 of the Rehab Act, is to ensure that when a candidate sits down to take a test, at the end of the day, the result isn't, oh, this person clearly has dyslexia. It's, oh, this is what this person knows and how they can, you know, explain and answer. So we believe it's critically important, and we have been actively enforcing this provision for some time. So when we initially put our regulations into effect in 1991, there weren't, there were provisions, and there was this best ensure language that I've just, read and discussed. David, could you advance the slide, please? Sorry. So then we have updated our regulations once under the ADA, and that was in 2010. And what we did when we sort of went through that process was we looked at all of our regulatory provisions, and we sort of determined that there were some places where we could give more guidance. And one of these was in the area of testing accommodations, and it was based on information we had seen from complaints that had come in, standard things that were going on with testing entities. And so we revised our regulations in 2010, and we revised the testing accommodations provisions as well. And those efforts, those revised regulations clarified and refined what we had seen over the past 20 years. So, David, please advance the slide. One of the things that we did when we revised these regulations was in our original 1991 regulations under the ADA, we had discussed in guidance to the regulations what we thought, how we thought testing entities should implement some things. And what we had found is because it was only in the guidance, testing entities sort of ignored it or weren't really doing it faithfully. So we elevated that guidance language to regulatory text. And it was in two primary areas. It was in the bounds of the process for requesting testing accommodations and the bounds of appropriate documentation requests under the ADA. So like how much information can a testing entity ask for, what is reliable, et cetera. And then we also set out in the regulations that testing entities need to handle all of this in a timely manner so that candidates with disabilities can actually take the tests. So those were, and we also set out what we thought was the proper weight that a testing entity should afford people with disabilities on the sorts of documentation that they provided. So now I'm going to turn it over to Nabina, and she's going to talk a little more about testing accommodations and basics.
So David, could you advance the slide? Great. So the very first issue is what are testing accommodations? Testing accommodations are modifications to the regular testing environment and auxiliary aids and services that allow individuals with disabilities to demonstrate their true aptitude or achievement level on standardized exams or other high-stakes tests. So this is sort of the flip side to what Robbie discussed about who should be accommodated, people with disabilities, in order to allow them to demonstrate their actual aptitude as opposed to their disability. So that is what testing accommodations facilitate. Next slide, please. Then what kinds of tests are covered under this provision of the ADA? Certainly college entrance exams such as the SAT or the ACT, which is of particular concern here. But just for your information, other examples of covered exams include high school equivalency exams like the GED, high school entrance exams such as the SSAT or ISEE, exams for admission to professional schools like the LSAT for admission to law school, admissions exams for graduate school like the GRE or the GMAT, as well as licensing exams for trades like cosmetology or professional purposes like bar exams for the legal profession. Next slide, please. Then who is eligible to receive testing accommodations? Robbie touched on this a bit, but individuals with disabilities. And it's important in the context of high school students especially to note that a person with a history of academic success can still be a person with a disability who is entitled to testing accommodations under the ADA. So important concept here that just because a person has managed to have good grades and perform well does not mean that they do not have a disability. Okay, next slide. So documentation requirements, and this is something that Robbie also touched on that the revised regulations clarified. Documentation requirements must be reasonable. Requests for supporting documentation should be narrowly tailored to those materials necessary to determine the nature of the student's disability and his or her need for the requested testing accommodation. And in combination with that, we need to be cognizant of the fact that appropriate documentation will vary depending on the nature of the disability and the specific testing accommodation requested. But the takeaway here is that testing entities should not be asking for everything under the sun about a student who's applying for testing accommodations. Those requests from the testing entity should be narrowly tailored to the information necessary to determine whether a testing accommodation is needed. Next slide, please. And then regarding specific types of documentation, if a student has a record of receiving past testing accommodations, that type of information should be given considerable weight by the testing entity. So proof of past testing accommodations in similar test settings is generally sufficient to support a request for the same testing accommodation for a current standardized exam. And the reasons for that are fairly obvious. We think that, you know, if the person has requested testing accommodations previously and has been vetted for those previously and received them, then that is a very good indication that they should be granted again in a similar testing situation. So if we move to the next slide. Can we get the next slide, David?
Oh,
it is there. Okay. So a specific example of this is formal public school accommodations. So if a student is receiving testing accommodations under an individualized education program, an IEP, or a Section 504 plan, he or she should generally receive the same testing accommodations for a current standardized exam. And the reasons for this are as discussed, and Robbie will actually discuss a little more in depth why specifically IEPs and 504 plans are reliable indicators of the need for testing accommodations in similar situations. So I will hand it over to Robbie.
Thank you. David, could you please go to the next slide? So, you know, this was a really important concept. And when we revised our regulations, we felt very strongly about it. You know, we went through notice and comment on this issue. You know, the slide here, which has a lot of text, and I'm not going to read, basically gives some of the rationale about why we felt IEPs and 504 plans were important. But some obvious reasons. It's a team of folks that know the candidate. You know, it's a balanced team. It represents a school district, their personnel, teachers, the family, you know, evaluation, diagnostic evaluation tools and things like that. And that group of folks is making a determination about what that student needs in testing situations, and a wide range of testing situations that come up in school. In addition, you know, IEPs and 504 plans are the process, you know, sort of the end result of a process that's set out by federal law. And so under IDEA and Section 504. So, you know, we logically believed and strongly believe that that is probably some of the strongest evidence a testing entity can get about what is appropriate for a student with a disability. It's been carefully considered. They know the student. They've seen the student. They've observed the student. You know, and so if that sort of documentation exists in an IEP or a 504 plan, that is the sort of documentation that an SAT or an ACT sort of test should say, yeah, okay, that makes sense, you know, and we're going to grant those requests for accommodations. And what we had seen historically was that wasn't the case. You know, IEPs or 504 plans would state what they would state. Testing entities would ask to see them, but then they would discount it. So, you know, we made clear that this is critical and it should be deferred to. Next slide, please. And this slide gives an example, and I will read it. Considerable weight is warranted, because this sort of explains what I was just talking about. Considerable weight is warranted when a student with a Section 504 plan in place since middle school that includes the accommodations of extra time and a quiet room for testing is seeking those very same accommodations from a testing entity covered by Section 309 of the Act. Testing entity receiving such documentation should clearly grant the request for accommodations. So that is, you know, basically the heart of this and why we think IEPs and 504s are so relevant for testing entities. I will also talk, advance the slide please, David. I also wanted to mention one other area where we tried to be more precise was on qualified professional. And, you know, one of the other issues that we've seen over the years in our enforcement of the ADA and this provision is that, you know, a testing entity will have some, you know, folks that they send off reports to, they send off documentation to, you know, and those folks will make their decisions sort of just based on, you know, raw data. They've never laid eyes on these folks. And, you know, they pick them apart. And, you know, we felt that if documentation was provided and it was from a qualified professional who had made an individualized assessment of a student that supports the need for the requested accommodations, that should take precedence over reports from, you know, sort of the picking apart by the testing entity. And another area where we pointed out that was important was that, you know, when a qualified professional is, you know, conducting a diagnostic neuropsych or something of a person, you know, there's whole batteries of tests that they can choose to use. If they don't use a specific test or like a subset of tests, that should never be a circumstance where a testing entity can say, oh, well, that person, you know, wasn't properly diagnosed. So we also pointed that out in our regulations and guidance as well. If you advance to the next slide, David, here's the bottom line on qualified professionals and this entire discussion. When an applicant's documentation demonstrates a consistent history of diagnosis of a disability and is prepared by a qualified professional, has made an individualized evaluation of the applicant, there is little need for further inquiry into the nature of the disability, and generally testing entities should grant the requested modification, accommodation, or aid.
So can we get the next slide, David? So another area that the revised regulations focused on was how quickly should a testing entity respond to a request for testing accommodations. And the answer is that they need to respond in a timely manner, so as to ensure equal opportunity for individuals with disabilities. And to tease that out a little bit, there's no set number of days that we will consider to be timely or not timely, but rather it's measured by the fact that the process should provide applicants with a reasonable opportunity to respond to any request for additional information from the testing entity and still be able to take the test in the same testing cycle for which he or she applied. So this is important because as people might know, an applicant may apply for testing accommodations and then get not necessarily a yes or no decision back from the testing entity, but will be notified that the testing entity would like more information in order to evaluate the request for testing accommodations. And so it was important to us that we focus on the fact that not only does the testing entity need to make the decision in a timely manner, but that is included in that decision-making time period is an allowance for the testing entity, one, to request further information, and two, for the applicant to submit that same information. And that all needs to be done in a timely manner, again, so that the student can get a final decision and still be able to take the test in the same time frame that they requested. So then next slide, please. So then on a slightly different topic, but still related, we have a slide that says, how should testing entities report test scores for test takers receiving disability-related accommodations? And the answer, not too surprisingly, is that testing entities should report accommodated scores in the same way that the same way that they report scores generally, which is to say that testing entities should not be noting in any way on the score sheets that the person received testing accommodations. And we bring this up because we've seen in other, in some testing accommodation instances where some testing entities were in fact reporting the scores differently. So where a testing entity is reporting scores of tests taken with accommodations in a different manner, we call that flagging, and we've defined it here as the policy or practice of reporting scores from exams taken with testing accommodations by including a statement or notation indicating that the exam was taken under non-standard conditions. And it's our position that flagging policies that impede individuals with disabilities from fairly competing for and pursuing educational and employment opportunities are prohibited by the ADA. And that is, again, a concept that we've seen, or an issue we've seen with some testing entities, specifically in the LSAC litigation that we'll touch on later in the webinar. Next slide, please. So the weight of technical assistance, so that is the document that we, the department, put out in August that talks about our testing accommodation regulation and guidance and gives some further examples. So that's called technical assistance, and although DOJ technical assistance is not law, it is generally afforded deference by federal courts. And that's important to note. We have heard sort of second, third hand from people who have heard from testing entities saying, responding in essence to our technical assistance that, well, that isn't the law. And that's true, but again, it is afforded deference in federal courts. As the department's interpretation of our own regulations, our technical assistance, as it is here, is entitled to deference under the Supreme Court case Auer versus Robbins. So as such, testing entities should abide by the technical assistance, and to that end, we urge people to cite to the technical assistance or send it freely to whomever they think would benefit from reading it, or both. Next slide, please. Then the guidance to the regulation is another source of interpretive assistance in addition to the technical assistance. So some of this is a terminology issue here. So what we call, quote unquote, the guidance is actually information that is appended to the published regulation that discusses much of the regulation, and that is located in two spots for anybody who's looking for it in the regulation itself, at Appendix A to Part 36 and Appendix C to Part 36. There are two spots where this specific regulation, 28 C.F.R. 36.309, that is laid out in one of the earlier slides, is located. And this what we're calling the guidance that, again, is appended to the regulation, goes into even more detail than the technical assistance that we published recently about the nature of the regulation, and gives examples and talks about comments that were received in the notice and comment period when the regulations were being formulated. So that is actually a more in-depth source of information about the regulation than even the technical assistance, if anybody is interested to see that. So again, that contains a detailed discussion of the meaning of the regulation. And what we did with the technical assistance is basically sort of summarize some of the key points from the guidance and pulled that out in what we thought was a bit more of a readable and focused document. So the next slide, please, and Robbie will discuss.
Hi, I'm back. So what to do if you're still having trouble getting appropriate testing accommodations for your students. You know, there's no magical answer here, but we at the Department of Justice want to know about it. So we would ask that you contact us, reach out to us, let us know if you are having problems. And you can also reach out to the Department of Education, and they can also get folks in touch with us as well. I hope to have an email address set up, which I will have David give out freely to folks, and we're hoping that that can be a designated email address at DOJ where people can send you know, specific concerns they're having with a specific student. I think we also hope that, you know, to the extent that, you know, the states that are listening on these calls sort of approach things similarly, you know, are saying back to the testing entities the same thing, are being, you know, the testing entities are getting the technical assistance document, that will hopefully have an impact because, you know, especially now that these standardized tests are being used for college readiness assessments and are being used by an entire state on an entire day, you know, it needs to work. The system needs to work, and it needs to work for students with disabilities in particular. I will turn it back over to Nabina, who can talk a little bit about the leading case that we've done in this office that has informed so much of our recent work. David, please advance the slide.
So a couple years ago, the U.S. intervened in a case out in the Northern District of California titled Department of Fair Employment and Housing versus the Law School Admission Council. And when we intervened as a party, we brought claims under the testing accommodation provisions of the ADA regarding specifically LSAC's documentation requirements and its flagging policy. So many of the same issues that we've just discussed here were at issue regarding things like how much documentation LSAC was requesting from people in order to support a request for testing accommodations, the timeline in which they did that, and as well the way that they were noting the score results for people who were taking the test with testing accommodations. And maybe I should back up, but just point of information, the Law School Admission Council is the testing entity that administers the LSAT, which is the admissions exam for people wishing to go to law school. So a point near and dear to all the attorneys on the line, I'm sure. So we, the revised regulations had just come out, even though, again, Robbie mentioned that it wasn't new information in the regulations about these various topics. It was actually information that had been in the guidance to the old regulation, and it was that these pieces about reasonable amounts of documentation, timeliness, et cetera, were just elevated to the regulatory language itself. So we were looking at those specifically. And through some litigation, ultimately we came to a settlement agreement, and everybody entered into a comprehensive consent decree that everybody signed in 2014. And the decree requires that LSAC set up a nationwide compensation fund that's already been dispersed. It requires a permanent ban on flagging, and it called for expert recommendations for improving LSAC's testing accommodation processes, which are known as the best practices. So for anybody who has been watching this case, you will know that the expert recommendations were made in a best practices report. LSAC appealed the appropriateness of many of those best practices, and then that was also settled in court, where the court said that no, the bulk of the best practices are fine and should be implemented by LSAC. So those best practices are now being implemented by LSAC. If you're interested in more information about those, they are on our website, which we will give you in a moment on the next slide. But just a note here that, again, these best practices, while they operationalize the regulations that we're talking about here, it's only with respect to LSAC, and they're the only testing entity that are bound by those very specific best practices, which have been tailored to LSAC, but they are certainly a model for how a testing entity might go about its testing accommodation processes. So with that, if we can get the next slide. So we have listed here additional resources and information. The website for our disability rights section website is www.ada.gov, and there you can view the technical assistance document that we've been talking about, the guidance to the regulation, the best practices report from the LSAC litigation, and you can also find all kinds of information about the ADA. We also have a toll-free number that is 1-800-514-0301 that we encourage people to reach out to us if they have any questions. And we also have links here to both the technical assistance document and the LSAC best practices report, should anyone be interested in viewing those. And then the next and last slide was reserved for questions. And since this is a closed recording, we don't have any questions.
We have no questions, but again, if you have specific questions or if anything, comes to mind based on, the information that we provided on this pre-recorded webinar, you can feel free to, get the information to David Egner, who's hosting this, and then he can reach us, and then we can respond. We're happy to respond and help in any way that we can. We believe it's critically important that your students with disabilities are able to take this test and are able to get the same benefits as everyone else can, i.e. a college reportable score. And so, we would love to hear from you if you're having any difficulties in that regard.
Robbie, Nabina, thank you very much for today's presentation, and thank you also to your colleagues there at Department of Justice. For those who are watching this webinar, offices within the Department of Education, we are working very closely with the Department of Justice. So my office, the Office of Special Education Programs, our principal office, Office of Special Education and Rehabilitative Services, our Office for Civil Rights, and our FERPA office, our General Counsel's office. We're all very much appreciative of the work that the Department of Justice has done on this important issue, and we look forward to continuing our work with the Department of Justice and providing additional guidance and assistance where needed. So thank you all very much, and that ends this session.